Sits in a jail cell. He is back in Idaho, accused of killing young Michael Vaughan.
You're pure evil. You have no heart. You have no soul.
Wondra is accused of murdering her then 5-year-old son in 2021. Would you think you'll ever get the answer as to why?
No, because there is no answer to why. Why would somebody hurt an innocent little boy? What answer could you give? What answer could you possibly give? How scared was he? Did he ask for me? Did he ask for Tyler?
Stacey Wondra has been charged with first-degree murder and second-degree kidnapping and destruction of evidence.
Michael "Monkey" Vaughan went missing from his Fruitland neighborhood on July 27, 2021.
This is a criminal investigation.
Now, more than 4 years later, in newly unsealed court documents, Fruitland police named 4 people they believed are involved in Michael's murder. Those 4 names are ones we've heard before.
This is Sarah Wondra. This is Sarah's husband, Stacey Wondra. This is Brandon Shirtliff, Adrian Lucian.
As for what these 4 people have in common, they were all staying at the Wondras' home when Michael disappeared in 2021. That's just half a mile from Michael's home where he was last seen. In the PCA, police pointed to video evidence they say showing Shirtliff walking around the neighborhood. They say Shirtliff helped move Michael's body in a duffel bag temporarily to his mom's home in Kuna before standing guard as they buried him in the Wondras' Fruitland backyard. Stacey Wondra told police the 4 hoped to sell Michael for $10,000 each. He says the idea came from Adrian Lucian. Idaho News 6 is now learning Lucian was arrested and released in Indiana in October for a traffic-related misdemeanor. Sarah Wondra is currently serving time in the Idaho State Prison System for unrelated charges. She's eligible for parole in early 2026.
Karen, is there any connection between the Vaughan family and the home where police had been searching?
No, we've heard this more than once from the family representatives and from the police department that there is no connection between the Vaughan family and the home where this search took place.
As you know, from the time Michael went missing, this has been an all-hands-on-deck investigation, and it remains very active and an ongoing investigation. You can't take one of our most precious citizens from us and ever expect us to stop. During the course of this investigation to date, we received credible information that the remains of Michael Vaughan could be found in the backyard at 1102 Red Wing Street in Fruitland. As a result, the Fruitland Police Department obtained a search warrant for the residence along with the front and backyards. That search warrant was served on November 11th. It was a Friday. We served that late in the evening. Upon entry, officers encountered Sarah Wondra, one of the known occupants of the home, and Sarah was subsequently arrested based on probable cause that she had knowledge of Michael's death and failed to report that death to law enforcement. The following day, the Fruitland Police Department, joined by the Idaho State Police, the Idaho Mountain Search and Rescue, the Fruitland Fire Department, and the Fruitland Public Works Department, began a very methodical excavation of the backyard of the Wondras' home. During that excavation process, the Idaho Mountain Search and Rescue, Mountain States detection dogs deployed multiple certified human remains detection dogs on the property, all of them alerting to the presence of human remains. Ground penetrating radar was also used and deployed, detecting anomalies in the backyard. We completed the excavation of the entire backyard and removed over 250 yards of dirt. Prior to backfilling the yard, the dirt was meticulously sifted for any potential human remains. We did not find Michael's remains. Although the remains of Michael Vaughan were not recovered, we strongly believe, based on evidence, that Michael was abducted and is deceased, and that his remains were buried and later moved from the property. As of today, the whereabouts of his remains are unknown. However, the investigation is active, fluid, and ongoing. Once the excavation was complete, we conducted a thorough search of the Wondras' residence. The search was productive, and additional investigative evidence was recovered and is currently being processed.
An hour's worth of body camera footage showing Stacey Wondra FaceTiming with detectives and directing to where Monkey's body was buried in his backyard.
It's like right under that mound area. It's right under the mound. About where at compared to the trees?
A little like right to the right of the trees area. It should be, it should be a garbage bag.
Okay, what color is the garbage bag?
It would either be white or black. We only have two colors.
Is the duct tape still going to be over his mouth?
It should be.
Okay.
I didn't watch take them off.
Okay.
So you should have everything intact as it was.
He claims he watched the burial happen.
Okay. How far down is Michael?
I don't know how far she actually dug.
And the she he's referring to, that's his wife Sarah, another suspect in the case. Stacey says Adrian, a third suspect, was also there for the burial.
Out of 300 homes, police say canines tracked Michael's scent to the home where Stacey, his wife Sarah, and their two roommates Brandon Shurtleff and Adrian Lucien lived.
As Joe mentioned, a newly released probable cause affidavit filed in June lays out the interviews following Michael's disappearance. Again, during these initial searches, police say canines tracked Michael's scent to the fence line of the home where Stacey Wondra, his wife Sarah, and their two roommates, Brandon Shurtleff and Adrian Lucien, lived. All four of those individuals have been named people of interest in Michael's disappearance. One of Michael's neighbors told police they saw Michael riding a bike outside of the Wondra's home the day that he disappeared. Another neighbor said they saw that same tricycle at the Wondra's home during a garage sale months before Michael disappeared. The Wondras initially denied any involvement, but then in November of 2022, Stacey asked to meet with investigators. The PCA states Stacey claims he was home the night Michael was allegedly abducted and saw Sarah carrying Michael into the house. Stacey allegedly told police it was Adrian's idea to take a child to sell for money, and they would get a $10,000 cut. Stacey claims Sarah told everyone to, quote, follow her lead. Stacey told investigators they took him to Brandon's mother's home in Kuna that night, where they left Michael overnight. Stacey claims the other three returned to Brandon's mom's house the next day and brought Michael back to the Wanderers' home in Fruitland. Stacey told police Michael was not alive, and Sarah and Adrian buried him in the Wanderers' backyard. 2 days after Stacey's interview with police, they executed a search warrant and excavated the Wanderers' backyard. The affidavit says cadaver dogs alerted to the same area where Stacey told detectives Michael's body was buried, but to this day, Michael has not been found.
Good afternoon, everybody. Welcome in. Thank you so much for joining Missing PNW Crimes Revisited. My name is Samantha. Today is July 2nd, 2026. How the heck did we get to July already? I don't even understand it. Just a couple days before 4th of July. I hope everybody is going to have a great 4th of July. Stay safe, everybody. Oh, me and my family are getting together over at my daughter's house. All my grandbabies and kids will be there. Gonna have a really good time. Lots of food, fireworks in the neighborhood. So happy 4th of July to everybody, because you probably won't see me until after the weekend. Thank you guys so much for coming in. We got Chaos Mama coming in. Thank you so much for being here. Outdoorsy Life is here. Chuck Anderson's granddaughter is also here, all on the tanks. Thank you guys all so much for coming in, supporting Michael and supporting the Vaughan family. Preschool Granny and Suzanne is here. Thank you guys so much for being here. Brenda is also here. Thank you for coming. Great to have you guys all here. Under Your Scars is here. Sister Karen is here. Hello, hello. I'm seeing some new faces. So thank you so much for coming and joining and learning about Michael's case. Ruby Slippers is here. Thank you so much for coming in. Ray was here a little while ago. Beverly Lawyer is in the house. Thank you guys so much. And thank you, Rogue, for being a member for 3 months. I really do appreciate that. Let's just do a little dance for a member of ours who I just love so much. Thank you, Rogue. Goodness, Pam Fogel is also here. Thank you for coming in. It looks like Stacey Wondra's attorneys were quite busy on the 26th of June, but the courthouse is playing catch up with everything slowly coming in that was filed. So we're just going to talk about some things that have been filed, some things that were also sealed. Darlene is here. Chuck Anderson's granddaughter gifted 1 Missing PNW Crimes Revisited membership. If you received that membership, please tell her thank you. Thank you so much, hun. You didn't have to do that, but I really, really appreciate it. And I appreciate you so much. Thank you for being here. We've got Diane here. Jen R is in the house. Hello, hello. Thank you guys so much for being here. All right. So, yeah, we're just going to talk about court filings. I like court filings. I like court documents. Sometimes I don't always understand them, but I do my best to understand them. The new motion that was recently, well, everything was filed, like I just said, June 26th, but these are things new coming in that we can actually see. The paperwork's finally starting to come in. Payette County has a lot of stuff going on with a couple of cases, so I'm sure they're a little scatterbrained over there. But Stacey Wondra filed a motion to suppress the Thanksgiving letter to the Vaughan family. And if you guys don't know what that letter is, it is a letter basically confessing what he did, admitting what he did. It was a letter that he wrote either shortly before or right after he had tried to commit suicide in his jail cell. And he was actually on suicide watch at the time that this letter was found, and we're going to talk about it all. We're here to talk about Michael Joseph Vaughan. Michael was abducted July 27th, 2021. We're in July of 2026. It's been just about 5 years since Michael was abducted and murdered. 5 years since his family had not seen him, heard from him. They had to come with very difficult terms within the last couple of years that Michael is no longer with us. And now they need the public, they need anybody, because this is still an ongoing investigation. They're still looking for Michael. And we need all the tips that we can get to come into Fruitland. The telephone number for that is 208-642-6006, or you can email findmichael@fruitland.org. No tip is too big or too small. Let law enforcement decide whether or not that tip is credible. And please, please, please give the family some peace. Let Monkey come home, which is Michael's nickname for those of you that don't know. Our sweet Monkey. Give the family some peace, and let's bring Monkey home so he can be buried and laid to rest. There are 4 suspects in Michael's case, which is Stacey Wondra, who has already been arrested, already been trialed, already had a preliminary hearing where the judge did find probable cause to move forward to a trial. In recent court documents, the attorneys in the defense are trying to get first-degree murder and second-degree kidnapping taken out of those charges, trying to find a dismissal, saying that the judge did not have probable cause to move forward to trial. Trial is still set for September of 2026. And then there is Sarah Wondra, who is Stacey Wondra's ex-wife. Their divorce was final just this year. She is is incarcerated now for unrelated charges of Michael's abduction and murder, but she will be charged with those, just like Stacey, after she gets out of prison. And that will be October 2026 when she is arrested, she is charged, and will be sent to Fayette County to face the charges of first-degree murder, second-degree kidnapping, and destruction of evidence in Michael Vaughan's case. Then you have Adrian Lucien, who got together with Sarah, came up with a plan to sell Michael Vaughan, to find a child to kidnap and to sell them so that each one of them could collect $10,000 apiece. He plays a big role. If he wouldn't have came to Idaho, Michael may still be here. Brandon Shurtleff and Adrian Lucien too, they have both tried so hard to try to tell everybody that they had nothing to do with what happened, but we have been able to prove using their own words. Like Adrian Lucien says, they kidnapped that kid. Well, how did Adrian even know that they kidnapped the kid if he wasn't there and actually saw it happen or saw the aftermath of it? Yet he has never spoken to police to tell them what he knows. And Brandon Shurtleff, the same thing. Reiterated here up on my channel here at Missing PNW. You can go back, you can watch that interview that I did with him live. There's also a phone recording that I had with Brandon Shurtleff that is also up and available for you guys to listen to. It's in the Michael Vaughan playlist. I will add that to chat later, but Brandon Shurtleff swears up and down he doesn't know anything, yet he told Juanita Kelleher, the detective in Michael's case, that he saw Sarah and Stacey put the duffel bag that had Michael in it, by the way, in the crawl space or in the basement of their home. He says he saw that. When detectives asked him if he had an orange or a red duffel bag, he said he had a red Marlboro duffel bag and proceeded to ask the detective, "Have you found it yet?" What kind of question is that, Brandon? And there's so much more information in the probable cause affidavit and all the other court documents that have been coming out. Brandon Shurtleff, his own mom told police that he had to have a phone conversation with Sarah Wondra to verify his story before going in and talking with detectives. His own mother threw him under the bus one time and then refuses to cooperate with police from then on, I guess. But Brandon Shurtleff knows where Michael Vaughan is now. Police believe that Michael Vaughan was buried in the Wondra's backyard. Stacey Wondra confessed to that, said that he saw Adrian Lucien and Sarah Wondra bury him while Brandon stood guard and was the watch out to make sure that they could get it done. And Adrian and Sarah buried Michael in the backyard, according to Stacey Wondra. And if none of these suspects like what's being said, then they need to come forward and they need to talk to law enforcement, because right now, after Stacey's trial, he's probably going to testify at the other three's court hearings against them in court. So Adrian, Brandon, if you guys don't want this side of the story coming out, you best go down and talk to Fruitland and, tell them everything you know, everything you saw, and give more facts. Because we do know that Stacey Wondra is a habitual liar. And we do want to hear from the other suspects in this case because we want the truth. The Vaughan family deserves the truth. Michael Vaughan was murdered, kidnapped, 5 years old, in his neighborhood by these four monsters. Brandon Shirtliff knows exactly where Michael is because police believe that Michael was taken from the Wondras' backyard and put in an unknown location. And Brandon, we want to know where Michael is. Where is Michael Vaughan? We want him to come home. If you have any information, please call the tip line 208-642-6006 or email findmichael@fruitland.org. No tip is too big or too small. We want Michael home. We're Monkey's Army, and we're not going anywhere. We're not going anywhere. Thank you, Shannon, so much for being here. I see you. Let me see. Yeah. Why have the other two not been arrested? I get this question a lot. Fruitland is a very small town. Very, very, very small. None of these suspects have enough money to get their own attorney, so they get their attorneys for free, which costs the county and the state of Idaho money. And because of that, and having enough people to move forward with trial, having enough, attorneys, defense attorneys, even Mike Duke, having him put together the case and everything else. We cannot try all four of these suspects all at once. One of them could be let loose. Like, you get one chance and one chance only. Each one of them is also, by law to get a speedy trial. And you can't really give that when you're working with all four suspects. And that's just in Michael Vaughan's case, plus all of the other caseloads that they have, which are a lot. So it's very difficult to prosecute all four at once. But mark my words, there are things moving. There are things moving. I believe Brandon Shirtliff is going to be arrested right after Sarah Wondra. I think that is coming sooner rather than later. So I want to talk about, we already went over, there's a dismissal. That dismissal is based on evidence, the motion to dismiss for lack of probable cause. The judge did see probable cause. We've already talked about this in other lives. We went over this entire motion. It's one of my most recent lives if you want to go back and look at it. But I do want to share my screen here and go over, let's see. Hold on one second. I am just trying to make sure I know which one I want to put up here. Sorry, I'm trying to make sure this is the right document. Guess we'll find out. Oh, no, that's not it. Here it is. Okay, so in this document, they have filed something to seal records, and it's for the dismissal. But what I am finding out is it's to seal the exhibits submitted with the memorandum in support of the motion to dismiss pursuant 19815A filed on June 18th, as well as exhibits attached to that memorandum. So basically, they want the exhibits of all of that to be taken out, and so not the actual motion itself. So that motion is right now still available. If you haven't seen it and you want to read it. And that order to seal it did go through. That's what this is. The order to seal records. And it says, now, therefore, it is ordered that the exhibits submitted with the memorandum in support of the motion to dismiss, filed June 18, 2026, as well as the exhibits attached to the amended memorandum filed June 23rd, be immediately sealed. Big key word here is the exhibits. So it's just the exhibits in that motion that are sealed. Because you can see here, the amended memorandum in support of motion for dismiss is available. I did put out a link last week in a post here on YouTube in the community, and it is all 35 pages here and available to see. And if you're wondering what the exhibits were, they were the transcripts from Exhibit A, which was the preliminary hearing transcript, day 1, and of course, day 2, day 3, the probable cause affidavit, the videos by law enforcement that were interviews with Stacey Wondra, both on November 10th and November 11th of 2022, and then the FaceTime visit between Stacey Wondra and his mother. But if you do want to see those, they're here at Missing PNW, so they are available still for you to see. You just have to look through all of the lives that we have done here. And Missing Persons Around the World is here. Hello, Sarah. Thank you for coming in, hun. Did Miss Brandy come in? She was getting her nails done with Pidge earlier. There she is. Hi, Sammy. Good afternoon, everybody. Pidge and I are listening while we drive. Thank you, everyone, for your continued support and love for Michael. Justice is coming. Thank you so much. Have fun with Pidge. Love you guys. Yep, they were getting their nails done not long ago. Pidge was getting the 4th of July nails. Brandy was getting some blue and some stuff that, well, for Monkey, but also 4th of July colors. So sweet. And so for today, now that we've gone over what they tried to, seal, and now that we know what has been sealed, let's talk about this Thanksgiving letter. There is just see this. I've got a lot of stuff up, so I need to. This is the motion to suppress the Thanksgiving letter. They are basically trying to say that Stacey Wondra's Fourth Amendment right has been violated here. Unlawful search and seizure, which is ridiculous, in my personal opinion. A motion to suppress is a request asking the judge to throw out tainted evidence under the Idaho Criminal Rule 12. The defense argues that evidence such as a confession or a written letter of apology was obtained in violation of constitutional rights like illegal search and seizure. To win, the defense must meet their burden of proof, typically by showing the court through facts and case law that the evidence was obtained unconstitutionally, and if the judge agrees with the defense's argument, the suppressed evidence cannot be used against Stacey in court. So that is what suppressed is. They're trying to completely throw out this letter. So the state of Idaho versus Stacey James Wondra, motion to suppress the Thanksgiving apology letter, comes now the defendant Stacey Wondra by and through counsel of record, names all of his attorneys, and hereby moves this honorable court to suppress what has become known as the Thanksgiving apology letter. Why? Because it was written around Thanksgiving time in November of 2022. This letter was the result of a search of Mr. Wondra's personal belongings while he was incarcerated at the Washington County Jail in violation of Mr. Wondra's constitutional rights under the Fourth Amendment to the United States of Idaho constitutions. This was dated June 26th, and then his attorney certifies that on this day he electronically filed this information. So that is that. And before I get into actually reading the court document, which is 15 pages long, but there's a lot of stuff we'll kind of skip over because there's a lot of, it is crazy. Yeah, when you're in prison, there is no legal search and seizure. I actually had to look up county jail because he wasn't in prison at the time. He was in Payette County Jail, I believe. Or wait, Washington County. Washington County Jail. Kimberly, it's good to have you here, hun. Thank you for coming in. Glad you were able to figure it out. She was having some problems getting some stuff. Ashley Higgins is here. Hello. Kelly is here. Hello, hun. Yeah, there's no privacy in jail. And I just wanted to go over some information that I did or I researched today involving all of this Fourth Amendment right crap. Because once again, Stacey Wondra wants to play victim, wants his attorneys to file something. Stacey's not the victim here. The Vaughan family is the victim. Michael Joseph Vaughan is the victim, okay? Stacey Wondra has been playing victim for way too long. And my personal opinion is this. He wants this taken out again, because this is another thing that his defense attorneys believe will hurt Stacey's case, because he wrote this letter while he was in his cell, no detectives, no one telling him what to do, what to write, nothing. Law enforcement didn't ask him to write this letter. He did it of his own free will. And from what I understand, Brandy and I talked about this briefly last week. The only thing that was really even in this letter, because it was an unfinished letter, and we'll get into more specifics about the letter, but Stacey was basically just saying, I'm sorry that Sarah did this. So he's still not taking accountability for doing anything, of course. Why would Stacey Wondra ever want to do that? Come on now. And, you know, it was an unfinished letter. But here's the thing. In the research that I did, the state of Idaho deputies and county jails have broad legal authority to search inmates and their property at any time without individualized suspicion. As prisoners have a significantly reduced expectation of privacy, these searches are governed by the Idaho jail standards and individual facility policies. Deputies are legally permitted to conduct several types of searches. Intake searches, which is when they're newly admitted as an inmate, they undergo through the booking and verify that no contraband is brought into the general population. Then there's strip searches, and then there's random sale searches. Deputies can search an inmate's housing unit, cell, or personal belongings without their permission. This helps limit the possession of unauthorized items, contraband. Body cavity searches is something else that they can do. That does require a higher legal threshold, but it's still something they can do. Also, in Idaho County jails, inmates effectively forfeit their Fourth Amendment rights against unreasonable searches and seizures. This is all Idaho code, you guys. This is all state law in Idaho that I found today. Fourth Amendment right against unreasonable searches and seizures, according to the United States Supreme Court precedent, which applies to all state and federal courts. Correctional deputies do not need a search warrant or individualized probable cause to search an inmate's person, living area, or property. And that's what this was. His property, in his tote, in his little basket. Okay? The Fourth Amendment in jail, no reasonable expectation of privacy. The U.S. Supreme Court establishes in Hudson versus Palmer that incarcerated individuals do not have a reasonable expectation of privacy in their prison cells. Warrantless searches. Because safety and security are the paramount or the main interest of any institution, deputies are legally permitted to conduct suspicionless searches of a person, cell, or belongings at any time. Or belongings. This letter was part of Stacey Wondra's belongings. And then I went even further. What about letters? Okay. Can a deputy read letters, whether they're in an envelope to be sent off or written and not in an envelope to be sent off? Personal letters can be intercepted and read by a jail deputy and can legally be used in court as evidence of an inmate's guilt. If an inmate writes a confession in a non-privileged letter, such as to a family member, friend, or other person, as long as it's not Stacey Wondra's attorney, prosecutors can introduce that letter at trial to prove the inmate committed the crime. So this can be used as evidence in Michael Vaughan's case. The letter is admissible under specific legal rules. Why is it legally admissible and not invalid search? Because inmates do not have a reasonable expectation of privacy. Now we're hearing this again. They do not have privacy regarding personal mail either. The deputy intercepting it does not violate the Fourth Amendment. The evidence is not considered tainted or illegally obtained. Excuse me. Statements made by a defendant are not excluded by the hearsay rule if they are offered against that defendant at trial, which is basically kind of like what this is. It's like a third party thing because he's confessing in this letter. Voluntary admission. The Fifth Amendment protects against compelled self-incrimination, like being forced by police to confess. If an inmate chooses to write down a confession entirely on their own, it is considered a voluntary statement and is fully usable against them in court. How the prosecution uses the letter. The prosecution must prove the inmate actually wrote the letter, which we know he did. It was in his items. He's in a cell. He's in Washington County. He's being held. He wrote it. They usually do this through handwriting analysis, looking into an inmate's return address, ID number, using jail security footage showing that the inmate is actually handwriting this letter, this mail, whatever you want to call it. While a written confession is powerful evidence, Idaho court generally requires some independent corroborating evidence showing a crime actually occurred to secure a conviction, which we have more of Stacey Wondra's confession, not only to detectives, but also to his mom, which is another thing they're trying to have thrown out because, again, it's huge. Stacey Wondra's mom talking to the jury is going to be damning to Stacey Wondra. The court is going, like, those juries are going to love Stacey Wondra's mom. Love her. The only one major exception out of all of this, out of it all, legal mail. If it was an unmailed letter and it was being written to Stacey Wondra's defense attorney or to court, it is strictly protected by attorney-client privilege. And if your deputy reads a letter addressed to an attorney and hands it to the prosecutor, that is severe constitutional violation. A defense lawyer could successfully move to suppress the letter. And this letter wasn't written to Stacey Wondra's attorney, wasn't going to be sent out to his attorney. This was a letter going to be sent out to the Vaughan family, confessing, telling them that he was sorry for what Sarah Wondra did, right? Am I getting that right? Yeah, because he won't admit to nothing. He's such a wuss. He really is. Anna Lisette, thank you so much for coming in. They are going to try as much as they can to delay things. This is probably part of that process. I have not had a chance to read this, so it's going to be my first time reading it. So, let's see. Chuck Anderson's granddaughter says, yes, that's how police calls from prison has their channel. I guess the defense will get delays and they will still be filing this stuff a couple of years from now, in her opinion. Which judge will rule? I don't know which judge they have right now to rule over his case. Ember, thank you so much for coming in. It is so good to see you. Let's see. Kelly says he wasn't talked into writing that letter. That was all done on his own free will. Exactly. Jen says, I can smell his desperation. They have to try anything. He knows what a jury will see. Well, yeah. And then you talk about this Thanksgiving letter and the fact that he also tries to commit, suicide prior to or after writing this letter. And that in itself speaks volumes too, right? Because at this particular point in time, Stacey Wondra is feeling guilty, even though, and I think it actually had more to do with the fact that he's FaceTiming his mom and he had to admit to his mom everything. I think he was feeling very heavy burden at this time. And that's why he did what he did. And I mean, and he would have been successful had the guards not came in. Like, it was a successful attempt on, well, it would have been a successful attempt on his part. 6 cents Melia in the house. Thank you so much for coming, hun. The defense has to give a defense no matter how much it requires grasping at straws, or the accused could say he wasn't represented effectively. Exactly. We're expecting all of it. We are expecting more. And will we find out whether or not this letter gets taken out of court? It's not there now, so we don't know what the judge, if he's going to throw this out or not. From what I have read, the judge has no reason to whatsoever. Mixed Born here, all the way from Scotland. Thank you so much for coming in. Thank you for being a part of Monkey's Army. Kelly says he was sad before he wrote the letter. He didn't write the letter till after his confession to his mom. Is that correct? You know what? I don't know. There are confusing timelines with this letter. I was originally told that he wrote the letter and then tried to do that to himself. But I can't make sense of the fact that when he wrote the letter, he was on suicide watch. So had he already tried to and then wrote the letter while he was in there? Or had he wrote this letter prior to being put on the suicide watch? I cannot make sense of it yet, Kelly. I do not know. 6 cents Millie says that I think Stacey was manipulating his mother for sympathy and feeling sorry for himself. Yeah, well, he was also wanting money when he called to talk to his mom, because right at the end, his whole persona changes and, hi, babe. Hi. He starts talking about the money that his stepdad or dad was supposed to send him, and then gets aggravated and upset when he finds out that he's not being sent any money. Yes, he was on S watch. Don't know if it was while he was writing the letter, but when the letter was found in his stuff, he was on S watch. So was he writing the letter before he went into S watch? Don't know. That's what I'm saying. But this letter was written sometime right prior to him trying to, or after the fact, which I'm pretty sure it was beforehand. I'm trying to figure out, though, why he was in S watch. Maybe it was because they found the letter and then they put him in S watch. I'm very confused about that. But in court, when we were at the preliminary hearing, they do talk about the S letter, and they do not talk about what's in it. What I heard was from Brandy herself. No problem, hun. You would think because he's on S watch that it was found prior to, right? Or I don't know. I don't understand it, but he wrote it, right? Yes, please hit that thumbs up, get it out in the algorithm. Today was another spur of the moment live. I put this up just a couple hours before I went live, so please click the notification bell if you want to get notification. And let's go over this court doc. I have not read it yet. So we already saw that they put in a motion to suppress the Thanksgiving letter. And now this is the amended. Let me see. Oh, wait. Is that what this is? No, it's not. Hold on. I will get to it. We don't want this. That. We don't want this one. Okay, this is the one. My kitty is hungry. Daddy just come home. So you're going to hear him in the background. Mister. He gets all excited when he comes home. And he's instantly hungry. Okay, so this is the one we want. This is the memorandum in support of the motion to suppress Thanksgiving apology letter. Okay, so comes now the defendant Stacey Wondra by and through counsel, naming all of his attorneys, and hereby submits the memorandum in support of the motion to suppress what has become known as the Thanksgiving letter. This is the nature of the case. Stacey Wondra has been charged with first-degree murder, second-degree kidnapping, and destruction of evidence in the disappearance and presumed murder of Michael Vaughan. Presumed murder. He always throws that in there. The magistrate court bound the case over to district court following a 3-day contested preliminary hearing. State of the facts and course of proceedings. On July 27, 2021, Michael Vaughan, 5-year-old boy living in Fruitland, Idaho, went missing and was never found. After an intensive search involving multiple agencies and utilizing exhaustive resources, law enforcement began focusing on Stacey and Sarah Wondra, who rented a home in a subdivision within a half a mile of Michael Vaughan's home. On August 2nd and 3rd, a live scent canine unit searched the surrounding neighborhood and reportedly showed interest in the house located at 1102 Red Wing in Fruitland. This was the home of Stacey and Sarah Wondra. Cell phone tower data and surveillance footage established that Mr. Wondra and Sarah Wondra were in the neighborhood at the time of Michael's disappearance. It was also discovered that Stacey and Sarah had 2 house guests, Brandon Shirtliff and Adrian Lucian. On November 5th, 2022, Mr. Wondra contacted the Fruitland Police Department from the Washington County Jail, where he was incarcerated on unrelated federal charges, and requested that they come speak to him. He also requested to speak with detectives on November 10th of 2022, in which time he requested the same deal that was offered to Sarah. A month prior to November of 2022, Sarah was offered a deal that she did turn down, and when Stacey Wondra found out that she could possibly get a deal, he immediately contacted Fruitland and wanted them to come in. So he is the one who contacted Fruitland detectives to come in and talk to him about Michael Vaughan's case. It looks like this is just going over the same thing as the last court document did, just talking about Michael's case. I'm going to go ahead and read through it this time, but next time, if the court document says this information, we're just going to skip right over it so we don't have to keep reading this particular part over and over again. It also says, during the course of several hours of interviews with Mr. Wondra and with law enforcement, he made numerous statements regarding what he saw Sarah and Brandon and Adrian doing, including Sarah bringing Michael into their home, taping him up with duct tape, putting him into a duffel bag for transport, and placing the duffel bag in the back of the GMC truck in order to transport Michael to Brandon's mom's house in Kuna, Idaho. Trigger warning, everyone. Please protect your mental health if this is difficult to listen to, because it is very difficult to hear. Mr. Wondra told law enforcement that Sarah, Brandon, and Adrian returned to Kuna the next day to discover that Michael had passed. They brought the body back to 1102 Red Wing house in Fruitland, where Sarah and Adrian dug a hole in their backyard and buried Michael while Brandon stood guard. On November 12th of 2022, a search warrant was executed on the Wondra's residence. The entire backyard was excavated in an effort to locate Michael's body. No human remains were located, nor any evidence linking Michael to 1102 Red Wing. And well, there is evidence because cadaver dogs did hit in that backyard. And something I did talk about was these cadaver dogs going to the backyard. I just did a live on it, but I did forget to mention that I was told by Julie Gibson when I spoke to her before my last live. Once the yard, we know that earlier in 2022, and it could have been the end of 2021, there was a cadaver dog that went out there to the property, and it did not hit in the Wondra's backyard. Now, when I was talking to Julie, the cadaver, she is one of the trainers of the cadaver dog used that did hit in the Wondra's backyard. She said that she came in the second day that the yard had been excavated, and she said what happens is scent pools happen when, so basically the yard, but once it's excavated, then scent pools go all over the yard because this dirt is being moved, it's being sifted, it's, you know, all of those things. And then of course that can also cause dogs to hit in different locations, just like in Michael's case. We had 2 cadaver dogs hitting in 2 different locations, but that's why there's different scent pools. And now that I understand these scent pools happening once the yard got excavated, it kind of explains why there wasn't a dog hitting earlier in that year or the end of 2021. But anyway, I just wanted to talk about that. Also in November of 2022, the exact date unknown, while Mr. Wondra was on suicide watch at the Washington County Jail, a detention deputy by the name of Bryce Crimmen was instructed to receive a letter from Mr. Wondra's private property tote in his cell. The letter has become known as the Thanksgiving apology letter, in which Wondra is alleged to have written to the Vaughan family expressing sorrow and remorse for what has happened to Michael. Bryce Crimmen testified at the preliminary hearing, and this letter was admitted into evidence by the Fayette County prosecutor. We're going to go over a small section of the Deputy Crimmen that found this letter when he is being spoken to by the defense here shortly. Hold on one second, you guys. I need to talk to my husband about something. Hold on one second. I need to meet. Hold on. Okay. Thank you guys for waiting for a second. So I want you guys to kind of hear how that went, but we do have the full preliminary hearing available in a playlist here at Missing PNW. If you want to go over the entire preliminary hearing, it is available here, and it's the only place that the entire preliminary hearing is available. On June 25th, 2025, a criminal complaint was filed charging Mr. Wondra with first-degree murder, second-degree kidnapping, felony destruction of evidence, and the pursuant violator in relation to the disappearance and presumed murder of Michael Vaughan. That presumed murder just pisses me off. Mr. Wondra, who was incarcerated on other unrelated charges, was not immediately arraigned on the criminal complaint. He was brought before the court and counsel was appointed on November 17, 2025. A contested preliminary hearing was held March 3rd through the 6th, 2026. At the preliminary hearing, no physical or forensic evidence was presented. And I have to talk about this here because you cannot have physical evidence. There is none when physical evidence has been destroyed. And in the dismissal that Stacey Wondra and his attorneys filed to dismiss that first-degree murder and second-degree kidnapping, notice in that dismissal, he isn't trying to get rid of that destruction of evidence because Stacey Wondra admits to destroying evidence, the physical evidence. And you cannot have forensic evidence if they were good, which they were very good at getting rid of the physical evidence in this case, which is a lot. Selling furniture, getting rid of cars, selling cars, getting rid and destroying SIM cards, selling telephones, getting rid of telephones. They did so much. We have gone over all the physical evidence. There is a lot of physical evidence that they destroyed. And you just can't have forensic evidence without it. To this day, Michael has never been found, and no independent witnesses testified that they claim to have known what happened to him. No evidence was presented that established that Mr. Wondra had anything to do with Michael's disappearance other than his own statements to law enforcement regarding what he saw Sarah Wondra, Brandon Shurtleff, and Adrian Lucian doing. But let's just throw this in here, Mr. Attorney. Establishes Mr. Wondra had nothing to do with Michael's appearance or disappearance other than his own statements. This is not true. It wasn't just Stacey Wondra's own words to detectives, his own statements. Stacey Wondra got in that GMC truck. He said Brandon Shurtleff put Michael in the duffel bag. Michael's in the duffel bag, covered in clothes, and Brandon Shurtleff picks up the duffel bag and puts it in the back of the GMC truck. Stacey Wondra knows this. When he gets in the passenger side of the truck, in the front, and decides to then continue to move forward and go to Cuna, to Brandon Mom's house, and Michael dies in that house in Cuna, or dies before they get to Cuna. And Stacey Wondra is helping Sarah and Brandon conceal Michael when he does that. Maybe they won't be able to prove that Stacey Wondra murdered Michael And if that does happen, huge if, they can prove that he helped conceal Michael, which in my opinion caused his death, which I don't see them ever getting the first degree murder charges dropped. But if they do, he will still be charged with kidnapping. He has to be. He voluntarily got into that. He did not call 911. He did not do what he was supposed to do, which is be a good citizen. Okay? On March 5th, 2026, during the preliminary hearing, the state amended the complaint in court by removing premeditation and focusing solely on the alternative felony murder theory. Despite no evidence being presented that Mr. Wondra was involved in Michael's disappearance and presumed murder, the magistrate court bound the case over to district court. District court arraignment occurred on April 3rd, 2026, at which time a not guilty plea was entered and Mr. Wondra requested the case be set for a speedy trial. The issue here that their defense attorney is trying to argue is that should the Thanksgiving apology letter obtained from Mr. Wondra by a search of his private property while he was incarcerated without a warrant and without his consent be suppressed? No. Here's the argument. Number one. Well, what is it? I here. The Thanksgiving apology letter obtained from Mr. Wondra by a search of his private property while he was incarcerated without a warrant and without his consent should be suppressed. A. Deputy Bryce Crimmon of the Washington County Sheriff's Office testified at the preliminary hearing that November of 2022, while he was a detention deputy for Washington County, he was directed to receive a letter from Mr. Wondra, personal property tote in his cell while Mr. Wondra was on suicide watch. This letter, allegedly written by Mr. Wondra to the Vaughan family, expressing sorrow and remorse for what happened to Michael, and was admitted into evidence at the preliminary hearing. Mr. Wondra asserts that this Thanksgiving apology letter seized from his private property by law enforcement while he was incarcerated without a warrant, without his consent, is a violation of his constitutional right to be free from unreasonable searches and seizures guaranteed in the Fourth Amendment to the United States and Idaho constitutions. Standard of review. The Fourth Amendment provides that the right of people to be secure in their persons against unreasonable searches and seizures shall not be violated. U.S. Constitution Amendment, it applies to the states through the Due Process Clause of the 14th Amendment to the United States Constitution, and we're going to go through by all of the codes. It is well established that warrantless search and seizures are per se unreasonable under the Fourth Amendment. And it just gives a bunch of different cases and their numbers to look at. To overcome the presumption of unreasonableness, the state bears the burden of demonstrating that the search or seizure either fell within one of the well-recognized exceptions to the warrant requirement or was otherwise reasonable under the circumstances. Even though inmates are incarcerated, they still retain their Fourth Amendment rights. And that is not what I read today. So anybody can look it up. The rights of the incarcerated, however, have limitations. Loss of freedom of choice and privacy are incidents of confinement. For example, the Supreme Court has held that the constitutional officers or officials may devise reasonable search policies to detect and deter the possession of contraband in their facilities. Such search policies for inmates are also guided by the Fourth Amendment's responsibleness requirement. Nothing that the touchstone of the Fourth Amendment is reasonableness. Over a century ago, the United States Supreme Court held that the Fourth Amendment does not prohibit the examination of prisoners' mail. And Stroud letters written by a detainee were later used as evidence at trial. The Supreme Court held that there was no constitutional violation because the letters were obtained under established practice, reasonably designed to promote the discipline of the institution. Some courts, however, have questioned that decision. Continued authorities regarding a prisoner's privacy interest in view of the Supreme Court's more expansive interpretation of the privacy interest protected by the Fourth Amendment. And then it does another case here in the United States in the Katz. The Supreme Court abandoned the notion that Fourth Amendment protections were tied exclusively to location or property rights and instead held that its prohibition of unreasonable searches protects an individual's legitimate expectation of privacy, including a reasonable expectation of privacy in one's communications. Following the Katz court have used differing approaches to address inmates' claims of unconstitutional mail inspections. A few courts have looked to the specific facts of the case to determine whether there was justifiable purpose for examining a particular individual's mail. And as I read to you guys earlier, because this mail was not going to be sent to his attorney, it was going to be sent to the Vaughan family, the mail thing here doesn't really matter because they are allowed to intercept that. He's just using other cases to show that in this case, they said. So if, then it says, allowing interception of the inmate's mail while investigating whether the inmates were bringing illegal drugs into the prison, holding actions were justified by the legitimate penological interest because there was reason to believe ongoing letters were addressed to material witness. Other courts have turned to the institution's privacy or policy to determine whether there was reasonable expectation or privacy in outgoing mail. No exception of privacy in letters that do institutional policy required that inmates to leave unsealed. No constitutional violation when letters inspected according to valid jail regulations that furthers institutional security. Some of these cases highlight the fact that the inmate was on notice that letters would be searched, which the court said preludes an expectation of privacy. No expectation of privacy when on notice his mail would be intercepted. Pre-trial detainee yields any expectation of privacy when he knowingly exposes to probable inspection of jail officials. Guarded language used in a letter indicated that the inmate was aware the letter would be inspected. No reasonable expectation of privacy after being informed mail would be monitored. No substantial expectation. Unveiled himself a process that exposed his correspondence to the plain view of prison officials. And then, let's see. A final group of courts have simply held that the institution's interest in maintaining security outweighs the inmate's privacy interest. Interest in deterring criminal activity allowed officials to open and copy outgoing mail. So that's what this is. This is just a bunch of different laws that he is using to try to convince the court that it is unlawful that Stacey Wondra's letter was taken out of his personal belongings from his tote. And then we've got C. Law enforcement officers did not have a warrant to search Mr. Wondra's private property tote in his cell, were not acting within one of the well-recognized exceptions of the warrant requirement, nor was the search otherwise reasonable under the circumstances to maintain jail facility security. Basically saying because it wasn't a security issue that the guard or the deputy was not supposed to take that letter, which in what I read, if it's some kind of written confession, they can absolutely take that letter and use it as evidence. Deputy Bryce Crimmin testified at the preliminary hearing that on November of 2022, he was a detention officer at the Washington County Jail tasked with safety, monitoring, and security of the facility, which included the inmates. He went on to testify that he had received an email from Mr. Wondra, or that Mr. Wondra had plans to send a Thanksgiving letter to the Vaughan family, and he was instructed that this letter was not to be sent out. While going through Mr. Wondra's property box that was removed from his cell when he was on suicide watch, that he noticed a piece of paper that said to the Vaughan family, "Happy Thanksgiving to the Vaughan family," something along those lines of that. He made a photocopy of the letter and mailed it to the Fruitland Police Department, which is where his dad worked. And at the preliminary hearing, we learned that the person who asked this deputy to get the letter, copy it, and put it back because it was an unfinished letter was his father that worked at a different sheriff's office, which if the district attorney's office had any inclination whatsoever that that was going to turn around and bite them in the ass later on because they were related, they wouldn't even be using this deputy as a witness in court, in my opinion. Deputy Crimmin testified that once he found the letter and photocopied it, sent it to Fruitland Police Department, he placed it back in Mr. Wondra's property. He did that because the letter looked to be unfinished. And officers investigating the Michael Vaughan case hoped that Mr. Wondra, by finishing the letter, might incriminate himself. On cross-examination, Deputy Crimmin admitted Detective Scott Crimmin with the Fruitland Police Department, who was working on the Michael Vaughan case, is Deputy Crimmin's father. And he reached out to Deputy Crimmin to enlist his assistant in investigating Mr. Wondra. Details were scarce, but Deputy Crimmin testified that to the best of his memory, he received an email advising of the letter and that it was not to go out. And this email came from Lieutenant Bettinger. He said, not recollect how Lieutenant Bettinger became aware of the letter in Mr. Wandra's private property, but he believed that information was developed before Mr. Wondra was placed on suicide watch. So there's your answer, Kelly. It's saying that they were aware of this letter before being put on suicide watch, which tells me he wrote that letter, tried to commit suicide, and then they put him on suicide watch. So that is an answer to a question that I've been asking myself since I went to the preliminary hearing. Deputy Crimmen further testified that no one, including Lieutenant Bettinger, directed him to go through Mr. Wandra's property. He did that on his own initiative. He testified that because Mr. Wondra was on suicide watch, he had the authority to go through his things, which he absolutely does. And I would think at that point, with Stacey being on suicide watch, that he had even more authority to be able to go in and check on Stacey, look through anything that he had. He believes that written down in jail policy somewhere, final deputy. So he's basically saying he believes it's written down somewhere that that policy exists, that he's allowed to go through Stacey's stuff. Finally, Deputy Crimmen testified that he put the letter back in Mr. Wandra's property tote in hopes that he would finish the letter. He could not recall if he was directed to do that by his father or if that was of his own, if he did it on his own. The conclusion, the letter in the present case is distinguishable from correspondence at issue in many cases cited above. This letter was not surrendered. Hold on one second. This letter was not surrendered by Mr. Wondra to jail staff to be mailed out of the jail. It was in his personal tote with other personal effects. Therefore, Mr. Wondra did not waive his expectation of privacy in the letter. We do not have an issue of the letter being a threat to the jail facility or a threat to any potential witnesses, nor could it be perceived as an attempt to plan or escape or arrange for the introduction of contraband into jail. The case that should be the focus here is Savage and the court's holding of justifiable purpose. Deputy Crimmen could not cite a valid jail regulation for searching through an inmate's personal effects when testifying at the preliminary hearing. Such jail regulations must be narrowly tailored under the case law cited above to further institutional security and place the inmate on notice that correspondence being sent out of the facility would be subject to inspection. There must be a justified purpose for intercepting and photocopying Mr. Wandra's letter, or it violates his Fourth Amendment rights. Oh, poor Stacey. Always violating some kind of right. Stacey Wondra himself has tried writing letters in his own handwriting to the court, screaming that his rights have been violated. So this is completely laughable to me. The search of Mr. Wandra's tote was clearly to investigate past action, not to prevent future harm to the jail facility or to maintain security. There are many mysteries surrounding the circumstances of how correctional officers obtained a half-written letter from Mr. Wandra's property tote in his cell. Likewise, there is no known information on the record regarding what policies or procedures the Washington County Jail had in place of govern such matters. So it's as easy as Mike Duke getting that information, I would be assuming. What is clear is that this wasn't a routine monitoring or outgoing mail situation. This was a coordinary. How could he even say it wasn't clear that this was a routine monitoring of outgoing mail when clearly this letter was to be sent off to the Vaughns? This was a coordinated effort from detectives in Fayette County investigating the Michael Vaughan case to obtain potentially incriminating evidence from Mr. Wondra without a warrant and without his consent. The Thanksgiving apology letter should be suppressed. And then it's signed and dated on June 26th of 2026. And basically that just says that it was electronically put out. Yeah, sorry, breathing. Yeah, it all irritates me too. It really does. It's so, even though we know his attorney has to do his job, has to defend him, Stacey Wondra constantly trying to say that his rights are violated when we all know they haven't been is frustrating for everybody, including the Vaughan family, because they have to put up and tolerate with all these little bitty tiny little things. When it's all coming out, all the stuff's filed on June 26th, but here we are July 2nd just finding out about it, and the information starts coming out slowly. You're putting up with this information then an awful lot. Like, I know it's not the court's fault for not having it all put out all at once, but as it starts coming out, how it's just so frustrating. And to hear him whine, there were plenty of things that I read today in the Idaho court laws that said they had every right to take that letter out and do whatever they wanted to with and use as evidence. Defend him from the evidence, but don't be dirty. I love you, girl. What if this had... I don't know. I mean, if Stacey Wondra is confessing something, he's confessing something, whether it's written in his diary or not. And I doubt very seriously that this was some kind of creative writing exercise. I mean, do they even have that? I don't know. Or if Stacey had kept a diary, what would be protection on those things? Let me look and I will tell you. Let's just see this. Hold on a second. Look up. Can... So from what I understand, it says in Idaho county jails, deputies and correctional staff are generally permitted to read inmates' personal journals and writings. When an individual is incarcerated, constitutional expectations of privacy are significantly reduced, and staff can review journals to monitor for security risk, escape plans, criminal activity, and or confession. So there's your answer. Had this been written in any other way, it wouldn't really matter. They are still able to get and read that letter. It is his personal. It is of his personal stuff. And if they're allowed to go through an inmate's stuff and that letter sitting in his tote box of stuff, they are allowed to look at it. Let's see. Hold on. I'm just trying to scroll. Oh, I forgot I can do this now. Hold on. So Brandy here, Michael Vaughan's mom, is saying, why are persons unrelated to Michael's abduction getting the information before the public? Don't worry. I have important all of the courts about those persons. Yeah, nice. It was a letter addressed to the Vaughan family. I do not know it. I don't think it was addressed as mail, but it was a letter to them. And it sounded like the deputies or other people from Fruitland Police Department knew it was supposed to be mailed out, and Deputy Crimin was told, do not let the letter be sent out. I don't know if it was in an envelope. I don't know if it had a stamp on it, but it was to be sent out. I just don't know how far along he had gotten in that aspect because the letter was unfinished. That's why they put it back. They wanted to collect more evidence. Like, what else would he say in that letter? What if this, let's see. Yeah, he is an attention seeker. Absolutely. Brandy, bite your left toe, Mr. Defense Attorney, sir. Right? Yeah. Angela said I did the same thing today. I actually researched for a couple of hours and found nothing to back up Stacey Wondra and his attorney's claims that this Deputy Crimin could not go through and get out that letter. And of course, they're really trying to talk about the fact that it was this deputy's dad that asked him to get the letter, to photocopy it and all that. We're talking about a little town. We're talking about where everybody knows everybody. So you're looking at a situation where it is not unusual for family members to, say, work at the same grocery store, work at different sheriff departments, in my personal opinion. Mixborin says that these monsters should have no rights. Makes me sick. It does. They shouldn't have any rights whatsoever. Kelly says, I hope the judge laughs at them for this BS. Yeah, just like everything else. When put on S watch, I was under the impression that they aren't allowed to have anything in their cell. Well, now we know. We have now been able to answer that by going through this. So thank you, Mr. Defense Attorney, for, trying so hard to get this Thanksgiving letter suppressed, because we're learning in this document that he put out that they knew about the letter before going into the S watch, which means Stacey Wondra wrote this letter before going into suicide watch. I believe he obtained it legally too, outdoorsy. Just going over. Alex Cooking, thank you so much for coming in. It's great to see you. A safety check. You know, yeah, because there's certain things, the safety of the prison or the county jail, they have to, there's a huge list from what I found today with different reasons why they can search somebody's cell in county jail. And within that list, a lot of it has to do with contraband and all of that kind of stuff. That's why I looked further into letters before even being put out into the mail or what. Letters are allowed to be looked at by deputies. I mean, somebody could be writing on a piece of paper and writing out a letter because they want to try to escape and they're writing it out. There's like lots of different reasons why. But in this case, the letter is Stacey Wondra's confession. He's apologizing, feeling the feelings, and, you know, trying to send that out to the Vaughan family. That's what I think is disgusting. Not that he wrote the letter. Okay, Stacey Wondra wrote a letter. But it bothers me that he wanted to send it to the Vaughan family. Like they want to hear from him, the person that abducted and murdered their child, their brother, their grandson. Imagine all the things they have found in cells. They would have to back and retry many criminals, right? My personal thoughts are that the distance is not far, but on traffic around Nampa is horrible. Hey, Purple. Good to see you, hun. Just going through chat. Reading some comments. Thank you guys all so much for coming in. When the garbage is put on the curb, it's discarded, so it's not private property. Missing persons around the world, you are absolutely correct. Thank you for your continued support. The drive is... And for those of you that are interested, because I was kind of interested, I did listen to this earlier. I'm going to listen to it with you guys now. But I want to let everybody hear what the defense had to say about had to say to Deputy Crimin. And my cat is being fed, so he is being loud. So let's play this. I think, let me see here. We're at 14 minutes, and then we'll kind of stop and go after it. I think it goes to, so I think this is like 15 minutes. But I think it's important while we're talking about it to go over the defense questioning Deputy Crimin.
Deputy Crimin, are you a deputy currently for the Washington County?
Yes.
And you no longer work in the jail facility, though?
Yeah.
And just to let you guys know, the defense attorney talks really low I can't do anything about the volume, so we're stuck listening to it the way that it is, but I do have the captions on here.
And you're on patrol now?
Yes.
Okay. At this time, what we're talking about here, you were working in the jail, though, as a jail deputy.
That's correct.
Okay. And just for clarification, Stacey Wondra is in that jail at the time?
Yes.
And is Washington County the facility where federal inmates being held on federal charges are often kept?
That's correct.
Okay. And is that why Stacey was there, to the best of your knowledge?
I believe so. Yes.
Okay. You indicated on direct examination you were cooperating with the Fruitland Police Department. Under what authority were you doing that?
I was currently just doing it right along with patrol at that time.
With Fruitland Patrol or Washington?
Washington. Yes.
Okay. Now, so when you say you were cooperating with Fruitland Police Department, does that mean that they reached out to you and asked for your cooperation?
Yeah, they called and asked if I would be able to assist in aiding in that phone call.
Okay, well, let's get right to it. Who's your father?
Detective Scott Crimmin.
And Scott Crimmin is a detective with Fruitland Police Department?
He was at that time.
Okay. And is he the one that's facilitating this cooperation from you, or requesting this cooperation from you?
He did request that from me.
Okay. In regard to this Thanksgiving letter that has been admitted, we just kind of flew right past how you kind of learned of that. You said that you learned from someone that there was a Thanksgiving letter, and it was, and you were instructed you were not to allow that letter to go out. Is that accurate?
Yeah, to the best of my knowledge.
Okay. Well, to the best of your knowledge, you either remember it or you don't.
I do remember an email that said that there is a letter, a Thanksgiving letter that's going to be coming from Stacey Wondra, and do not send it out.
Do you remember who that email came from?
Lieutenant Bittinger.
And do you have any idea how Lieutenant Bittinger found out about this letter?
I do not.
You just received an email from him or her? Sorry.
Yes.
Okay. And so, to the best of your knowledge, you received this information from someone else. It didn't come from you initially about the letter.
Correct.
Okay. And what was the date of the email that you received from Lieutenant Bittinger? Do you remember?
I cannot recall that.
Is it in those reports that you brought with you?
I do not believe so. I've already searched for that.
And not found it? So your testimony is that Stacey Wondra was on suicide watch at this time?
That's correct.
What are the protocols for the Washington County Jail for someone who's on suicide watch?
They're to be removed from their cell initially, and they'll go to a holding cell, and they're typically removed of all clothing, placed in a suicide smock, and that is essentially like a weighted blanket. It's the best way I can describe it, and placed on a 15-minute watch, so you can check on them every 15 minutes.
And does the jail have a written policy regarding going through the property box for the inmate? Do you know?
We are allowed to search the property.
And where does that come from? Is that in
So you're hearing Deputy Crimmin say we are allowed to check the inmate's property. And you also heard what is the protocol of S-Watch. Well, Stacey Wondra is removed of all of his clothing, put into what is called a smock, which is basically like a weighted blanket put over him and put into a cell alone with his, some personal things. And again, Deputy Crimmin says here that yes, he is able to go through personal items.
email as well, or is that written down somewhere?
That should be written down.
And do you remember, as part of your training as a jail deputy, being trained on that particular policy?
It was part of the training to do searches of the facility. That's correct.
Who was your supervisor at that time?
And then you have deputy saying that it is part of their training to learn and, go about searching the inmates' cells.
Direct supervisor, or do you want to change?
Direct supervisor would be fantastic.
At the time, Sergeant Wade.
And do you remember who directed you to go through Stacey's property?
Nobody did.
You just did it on your own?
Correct.
And so explain that to us a little bit. In the Washington County jail cell, was there a particular pod that Stacey was in?
I believe it was pod 600, but at that specific time of the search, I don't recall.
And is there anything special about pod 600? Is it maximum security? Is it isolated to, is it a mental health ward? Is there anything specific related to that particular pod?
I don't believe so. It is a smaller pod with only 2 cells inside of it.
Was Stacey housed alone by himself at that point? Do you remember?
I don't remember.
So your testimony here today is that you don't really know or remember how it was developed, that there was information, that there was a letter that he was writing to the Vaughans.
Objection, this state's testimony.
Response? I'll rephrase the question.
All right, go ahead.
Deputy Crimmon, can you tell us how the information was developed that there was a letter to the Vaughans in Stacey's cell?
The only information I had is I had an email, and that it was possibly in the works, and I was aware of it, but I just happened to locate it.
Okay. So let's talk about the timing of that. When you received that email, you don't remember exactly when?
I don't. I believe it was before that.
And you looked for that, but you can't find it?
I didn't write it down in the report, but I have found the email, I believe.
And was the email that you received about this letter, was it before or after Stacey was placed on a suicide watch?
I don't know. Should have been before.
To the best of your recollection, it was before?
Yes.
Would you like a minute to think about it?
Can you rephrase your question?
Think back to Stacey Wondra being in the Washington County Jail and you receiving an email from Lieutenant Pittenger that there was a letter, and that letter was not to go out. To the best of your recollection, was that before Stacey was placed on suicide watch or after? I'm not trying to trick you. If you can't remember, you can't remember. Washington County Jail, and you receiving an email from Lieutenant Pittenger that there was a letter, and that letter was not to go out. To the best of your recollection, was that before Stacey was placed on suicide watch or after? I'm not trying to trick you. If you can't remember, you can't remember.
It should have been before, but I don't know.
Fair enough. And so talk to me about.
I just want to see what he said right here. Should have been before, but I don't know. Because this defense attorney is asking him, did you know from this email that he was given, told about this Thanksgiving letter, this confession letter to the Vaughan family, wanting to know, did you receive that email before Stacey went to the Washington County Jail and was put on S watch? And he said, it should have been before, but I don't know. But because of the way that, this motion was written out, we know this was written prior to him going on S watch. Which would also answer the question of, he wrote this letter, tried to commit S, and then they put him on S watch, and they contacted this deputy by email and let him know this letter exists. It's in his stuff. Do not let it get sent out.
And so talk to me about this property box when an inmate is in the Washington County Jail, in a cell. They have a property box in there?
Yeah, it's that's why I described it, kind of like a tote where they can keep kind of their belongings, like so.
And is that tote made out of fabric, canvas, metal, wood? What is that tote?
Plastic. It's a plastic tote.
Okay, like a square?
Yeah.
Closable tote?
It's not closable. It's open top.
Okay. And that tote would typically hold the personal items for an inmate that an inmate is allowed to have in the jail?
Correct, within the cell.
And so when he was on suicide watch, was there someone that specifically directed you to go through that tote, or you did it on your own?
I don't recall. I do not believe anybody specifically directed.
So you don't really know whether you went through that tote because someone said we want to find that letter, or you went through that tote because he was placed on suicide watch and that was your protocol, that was your policy.
Nobody directed me to specifically go through his box today.
And the deputy is saying that nobody asked him to go through his property.
Did you have Stacey's permission to go through his tote?
No.
Did you have a warrant to go through his tote?
No.
This was, to the best of your understanding, the policy of the jail that you could do this?
Yes.
And you located the letter at that time?
Yes.
And were there any other letters in the tote?
I can't recall.
Your testimony here today is that you went ahead and copied that letter and you sent it to someone. Who did you send it to?
Detective Creighton with the Prison Police Department.
Your father?
Correct.
At his request?
I can't recall.
How did you send it? Hard copy or email?
Or email.
And you put the original back in the box?
Yes.
Now, he's writing a letter that is not to be delivered. You've been told. Why put it back in the box?
I wanted to see if you would finish it.
And you were asked by your father to help facilitate a FaceTime meeting with him and Stacey?
Correct.
And was that in relation to about the same time? Was it after you found the letter, after you sent the letter to Stacey, or was that before this FaceTime collaboration?
I can't recall. We're just married for my report for refreshment.
You may, Judge, I've asked the witness to give him permission to potentially refresh his recollection as to the timing of that.
Any objection to the statement?
No, Your Honor.
Yeah, so go ahead, Officer Deputy Kerman, just be sure, review it and then set it to the side. If your memory is refreshed, then go ahead and answer the question. If it's not, please just let Mr. Geddes know that, it doesn't help if you're merely reading from the report, or would be, if it's even.
Because, Kelly, because of the BS that has been created by a certain YouTube creator, because she is one of the people that helped put all of this information together for prosecutors, trying to find anything that they possibly can to have something thrown out saying that like you're saying, one of the detectives on the case, why does he say father as if that has any relevance? Because they're trying to prove in some way, shape, or form that because you've got Deputy Crimmin over here at Washington County Jail, and you've got Scott Crimmin, his father, over at Fruitland at Payette County Jail, that there is some kind of something going on here in the background. That there is, what is the word I'm looking for? Like law being broken of some sort. Like his rights are being violated because it was the father that was involved, somebody that was involved in Stacey's case. I'm not finding the words that I'm wanting to use, but basically they're just trying to find something hectic here. Yeah, bingo again, dirty. Basically trying to say that these police officers are dirty. Dirty's a good word to use. Dirty in that, you know, what they're doing is against the law, but it's not. Small town, family members work with each other. It's not a big deal. And let's not forget that, you know, this defense attorney's an ass anyway.
Does your memory refresh?
Yes.
Go ahead.
Thank you, sir. Can you, do you now have a better idea of when this collaboration to set up this FaceTime meeting between Stacey and the Fruitland Police Department was, what that date was?
Yes, the FaceTime visit was November 12th, 2022, according to
So this deputy is also responsible for helping set up the FaceTime that was between Stacey Wondra and Chris Madonna and Juanita Kelleher when they went to the Wondra's home to start excavating after Stacey Wondra had confessed to detectives that Michael Vaughan was buried in his backyard. So he was also involved in that, and that's what they're talking about here. So when you hear them talking with this deputy about the FaceTime, that's what he's talking about.
Was there anyone else you were working with besides your father, or was it just him?
Detective Anita. I heard it across.
Anita?
Her first name is Anita.
Is she a detective as well?
Yes.
Last name not remembered.
I cannot remember it. I usually refer to her as Anita Toll, but I don't believe that is her actual last name.
He's speaking about Juanita Kelleher.
And the actual date of the FaceTime meeting was November 12th?
According to the incident date on my report, yes.
So is it fair to say that you, were you told by your father to leave the letter in there hoping that he would say other things and continue writing the letter?
He could have, but I don't simply recall.
Is it common to search people's totes, inmates' totes at the jail?
Yes.
Do you do that all the time?
Yes.
So this wasn't the first time you had done that?
And he is saying that it's something that they do all the time. He answers yes. So you do it all the time? He says yes. So this is something that this deputy does all the time, searching the totes of inmates in Washington County Jail.
No.
Can you tell me if this is routine policy to search through totes when someone is put on suicide watch?
That would be, yeah.
And he's answering yes. So would you say that this is policy? Think you could go through and he says yes.
If I could just ask you to say yes or no, because the reporter's trying to get that down, and yeah, and now be so close. I mean, I think your yeah was pretty clear, but if you can remember just to say yes or no.
Yes.
So your testimony today is that your conduct on that day of searching through the tote is something you had done before with other inmates?
Yes.
How did you facilitate the FaceTime meeting? Was it on a tablet? Did you just go to his cell?
It would have been my coworker's work cell phone.
And you went to his cell?
We removed him from his cell and placed him in our in-talks room.
Okay. Who was on the other end of the call? Do you remember?
Detective Crimmon and Detective Adita.
Thank you. I have no further questions.
Any redirect?
Yeah, just a couple questions.
And then just a couple questions redirecting here by Mike Duke.
Is it possible that Anita Toll is Juanita Kelleher?
Yes, that would be correct.
Okay. And as far as you making the decision to go through the tote, do you wait for somebody to tell you to do everything when you're a jail deputy?
No.
Okay. Are you trained to take measures to secure the jail and provide for the safety of the jail that you're expected to do without being told?
Yes.
Okay. And going through personal property of inmates, are those one of the duties that you have had or that you had?
Yes.
Okay. No further questions.
Any recross?
No, not just. No. Thank you.
So that's basically his testimony. And he's asked by Mike Duke, are you usually asked by somebody to do your duties there at the jail? And he says no, because he's not. He's not asked. He is trained to do his job there daily. He doesn't need to be told what to do every day, all the day, every day, all the time. But this is the current stuff that came up. Opal just came into the house. Hello. If nobody told you today, you matter. Much love. Thank you, Opal, for coming in. I really appreciate you and your kind words. Just going through chat a little bit. Good employees don't have to be told to do their job. Exactly, Chaos Mama. Yes, it is policy. Thank you guys so much for being here and being good to one another in chat. Yep, they can search all they want under your scars. You are absolutely right. I hope they stretched before that reach. Oh gosh, girl, I love you. But this is the most recent court documents, even though they were filed. You're not a dork. Even though they were filed June 26th, like I said, it looks like lots of stuff was filed in. As it comes in and we can actually see it, I will come here, spur of the moment, probably, because I'm trying to keep up on all these docs. Because there's going to be a lot of documents coming in later on, or like trial. Hopefully they will allow the trial to be streamed, and then we'll be right here all day long in court every day, as exhausting as it sounds, and it will be, because it's very hard to keep up on cases. But I would like it to be streamed so that we can be here. We're waiting. So now that everything's been put over to Canyon County instead of Payette, we now have to wait for this new judge to start probably making new court dates, new hearing dates, because all of the other dates were for Payette County. The other thing that I noticed that was filed on the 1st of July was a motion to transport, which the document itself hasn't came in, but it is written in the Idaho court system. So I'm just thinking that that's some motion that they have to file to be able to transport him to and from Payette County to Canyon County, like we originally heard it was going to happen. But if this is a motion to transport, I'm wondering if they're not going to transport him back and forth every single day. Maybe he's going to be transported to Canyon County. I don't know. We'll have to see about that. But make sure to hit the notification bell. I did put Brandy Vaughan's YouTube channel up. Please click on it, go over, subscribe, like, comment on all of the things. We're trying to really help Brandy Vaughan, help her channel grow. She's going to be doing Monkey Monday. I mean, this last Monday, we saw so many people come. More people than I even get on my channel, more than I've ever seen come to a Monkey Monday before. And it is amazing to see that Brandy has so many people going over there to watch her, because what she has to say is important. You find out so much more of the specifics that have gone on, the feelings of the Vaughan family, while going through everything that's going on, the memories that she's sharing of Michael Vaughan, beautiful pictures, beautiful videos and stuff that she is sharing with everyone, with Monkey, with Buggy. It's just a great place to go and support. Brandy Vaughan wants to talk about a lot of different things. She's also been reading pages from her journal that she was writing after Michael was abducted and murdered. Some of that written before she even found out that Michael had been murdered. So please go over to her channel. A matter of fact, I will put it up right now so you guys have it nice and fresh. Go over, subscribe to her channel. Here it is. And make sure to go through and like all of her stuff, comment on her stuff, even if you just leave a heart, and share Michael's beautiful face, share his beautiful story, talk about Michael, put him up on your social media. Michael matters. Okay, he's never going to be forgotten. Monkey's Army is not going to allow that to happen. Michael Vaughan was abducted July 27th of 2021. 4 monsters are named suspects in Michael Vaughan's case: Stacey Wondra, Sarah Wondra, Adrian Lucien, and Brandon Shurtleff. And we want to specifically ask Brandon Shurtleff, where is Michael Joseph Vaughan? Brandy and Tyler want their son back. It's time for you to start talking. Tick, tick, tick. Time is running out, Brandon. Right now, everything is being blamed on you, Adrian, and Sarah. Stacey Wondra hasn't taken any accountability for himself. So when the cuffs come, and mark my words, Brandon, they are coming, remember, I tried to help you. I tried to help you to go down, talk to Fruitland, tell them everything that you know, and you refused. You refused my help. You refused to take a deal when law enforcement tried to find you in Montana, but you had already fled, didn't you? You did the live with me, and then you took off because you re-listened to that live and you realized just how many times you messed up, how many times you leaked information, how many times you said things that you shouldn't have said, that you knew were going to come around and bite you in the ass. And you still didn't take that deal when they came to Montana. And now your friend from Montana, Dan Guthrie, is going to prison. Pretty sure you're up there in Montana helping Dan do overstate and going over to North or South Dakota to help Dan with all of his drug dealings. We're keeping an eye on you, Brandon. You cannot run. You cannot hide. Fruitland knows exactly where you're at and what you're doing. And it is time for justice. Somebody out there knows something. You can help the Vaughan family. You can be Monkey's hero, the Vaughan family hero. You can call 208-642-6006, or you can email findmichael@fruitland.org. No tip is too big or too small. You can remain anonymous. You can collect over $50,000 with any information leading to the whereabouts of Michael Joseph Vaughan. Michael Vaughan is deceased. He has passed. No matter what rumors you hear on the YouTube streets, those are the facts. No law enforcement agency is going to come to the Vaughan family, say, Michael is gone, unless they know for a fact that Michael has passed. And that is a fact. Please make sure, if you're following Michael's case, to stay away from misinformation, disinformation, rumor, stupidity, and stay where the facts are, which is Fruitland Police Facebook page here at Missing PNW, and Brandy Vaughan's Facebook page and her YouTube. And we're just asking for anybody that has any credible information to please call in a tip. The case is still moving. It's still ongoing investigation. They're still trying to find Michael. The telephone number is 208-642-6006, or you can email findmichael@fruitland.org. Let law enforcement decide whether or not your tip is credible. Even if you think it's a rumor, you should still report it to detectives so that they can look into that information. And your information may put together puzzle pieces. And if the information that you're holding on to is bothering you, then that's a good sign that you should probably call and give a tip. Again, that telephone number is 208-642-6006, or email findmichael@fruitland.org. We want Michael home. Monkey's Army is growing bigger every single day, and we just want these suspects to know that we are never giving up. We're never stopping, not until all 4 of them are locked away in a prison cell for the rest of their life, or get the DP. I wouldn't mind either or, honestly. Okay. And yes, justice is coming. Thank you guys so much for being here, for supporting my channel, for supporting Michael, the Vaughan family. Here at Missing PNW, we believe that the Vaughan family, we know for a fact that they aren't guilty of anything. Fruitland Police has said that in the new probable cause affidavit. So the people that are still trying to say that the parents had something to do with it, just don't listen to it. There are different patterns with these people of interest, that is for sure. Yeah, Dan got charged. He's going to prison. Federal charges for transporting overstate drugs over state. I went over all of that information a while back ago. You guys can find that in the Michael Vaughan playlist here on this channel. Well, I hope everybody enjoys the 4th of July. Stay safe. Make sure if you have a lot. Hi, Dukes. Good to see you. Make sure if you're doing fireworks at home and you're not going somewhere, have burn cream. Make sure to take care of the littles. Take care of all the little ones running around. Keep them safe. Keep them out of the road at night after you're lighting off the fireworks, or put out stuff to let others know that there's kids in the neighborhood so nobody's getting hit by cars and all of that kind of stuff. Just stay safe. Have burn cream. Have a good time. Eat hamburgers and hot dogs and chips and all the American things. I am, I love the 4th of July. I love my independence, and we will be celebrating. So I hope everybody has an amazing 4th of July, and I'll be back as soon as I can find some more information to talk about. It is Chuck Anderson's granddaughter. Great family time. Enjoy it. All of the family time you can possibly get. You never know when you are or aren't going to get another day with your family member. And we're thinking about you, Monkey, wishing that you were here with your family on this 4th of July. Have a good night, everybody. Stay safe.